Thank you, Madam Acting Deputy President. This is a bill that is close to my heart. As a mother of 3 girls, I know how terrifying the prospect of child exploitation, starting from the online world, is to parents. As a barrister and a former prosecutor, I have dragged ordinary-looking people before the courts to answer charges of the most abhorrent behaviour, acts that make me feel sick to my stomach to recall them. Over and over, I heard defence counsel say that crimes about child exploitation images are victimless crimes. Victimless crimes? It made me so angry, because in every picture there was a real child, a barbaric moment of their short lives captured, circulated among the most repugnant people on the internet for their gratification. And sadly, those image-based offences, well, they're not the worst offences. Child abuse ordered over the internet, the barbarism inflicted to order in exchange for cash upon children anywhere in the world. Children abducted and held prisoner for this vile business, or their innocence sold by their parents, the people who are supposed to love and protect them. Grooming of children over the internet for sexual abuse, something too common, too easy, and yet so hard to counter in a time when digital connectivity has never been greater. Indeed, with more children of late being at home and learning and spending their recreation time online, the risk has never been higher. Last year there were 18,000 complaints made in Australia of crimes of this kind. That was double the year before. Authorities are expecting that number to increase again this year. Now, I've worked with and I deeply respect those people who continue to work to protect all of our children from these kinds of nasty pedophiles. The police officers in Task Force Argos, based in Queensland, my home state, are right up there with the best in the world. They work with and are trusted by their international counterparts because these crimes have puzzle pieces spread all over the internet and all over the world. And so, to the Task Force Argos girls and boys, thank you very, very much. To the champions at the Commonwealth DPP, my former employer, for full disclosure, thank you. Your enduring every day of these horrible crimes makes our community safer for all of our children. And at a personal level, I know it often takes a really serious personal toll on each and every one of you. Here's something that victims, parents, investigating officers and prosecutors have to deal with every day, and it's that the penalties that are imposed for these offences are too often too low. In 2018 to 19, 39% of convicted Commonwealth child sex offenders did not spend a single day in prison. Not one. And I think the mums and dads at home would be horrified to hear that statistic. It's important we value the discretion that we give to judges to weigh up the circumstances of the case, but it's not as though the need for these penalties to be taken seriously is a message that is new. It's not something anyone could be taken by surprise on. 39%, not a single day in prison, despite the innocence of children stolen. It just does not wash. So, what does this bill do? Well, it does 4 things, broadly speaking. It introduces new offences related to grooming activities and for websites and online platforms that are designed to host child abuse material. It introduces new aggravated offences for the most horrific types of child abuse engaged in while someone is outside of Australia, which again, sadly, is far too common. where an Australian travels to another country and inflicts upon a child who is not Australian usually, cruel, inhumane and degrading treatment. The third thing it does is implements a range of presumptions against bail and presumptions for imprisonment, meaning it will be more likely that child sex offenders go to prison, that they stay there for longer, and that it is harder for them to get bail. And finally, it introduces mandatory minimum sentences for the most serious types of child sex offences and for those who are repeat offenders to address the completely unacceptable situation we face at the moment, where 39% of offenders last year did not spend a single day in jail. The bill also implements recommendations from the Royal Commission into institutional responses to child sexual abuse to protect vulnerable witnesses by allowing them the automatic right to give evidence via a video-recorded interview and prohibiting their cross-examination at committal hearings, to minimise the number of times they need to have the horror of their experience revisited upon them. This bill complements a wide range of reforms that have already been brought in by the Coalition in this field. We've brought in tough new measures to stop child sex offenders from travelling overseas to abuse children. We've brought in Carly's Law, which targets online predators who use the internet to prepare or plan to sexually abuse children. And we've brought in a range of recommendations arising from the Royal Commission that I mentioned a moment ago, and improves the Commonwealth framework for offences relating to child abuse material, overseas child sexual abuse, the use of childlike sex dolls, forced marriage, the failure of people to report child sexual abuse, a very important recommendation arising from the Royal Commission, and the failure to protect children from such abuse. Now, we've heard some interesting remarks from those on the Labor side today about how committed they are to this bill, but none of that hides the facts. And the first of those facts is that Labor refused to support this bill when it was last before the Parliament in 2017. So they might talk the talk, but they definitely don't have a record of walking the walk. And as they foreshadow their plans to bring in amendments to this bill today to remove those aspects that are directed at increasing the penalties that are inflicted upon convicted child sex offenders, we see more evidence that they don't quite have the stomach to do what needs to be done today either. Now, they say they don't support mandatory sentencing on principle. And I understand that mandatory sentencing is a very serious measure. But it strikes me that offences don't get all that much more serious than these. And in any event, they're not consistent in their application of their opposition to mandatory sentencing on principle. If they truly opposed mandatory sentencing, why did they support it under the Rudd-Gillard-Rudd government to introduce mandatory sentencing for people who engage in people smuggling offences? If people smuggling is serious enough to justify mandatory sentencing, if people smuggling is serious enough to allow the principles of the Labor Party to be set aside, well, why not this? Why not the safety of your children? Why not the safety of my children? I have no qualms in standing up for the measures in this bill any day of the week. So let's go to what they are. The first thing that's been said by those on the other side about mandatory sentencing, both in its committee report and before the chamber today, is that there is very little evidence that mandatory sentencing increases public safety. They say that's the reason why they don't support it on principle. Well, if that were the case, they wouldn't have supported mandatory sentencing in the past. It's also not borne out by other circumstances where mandatory sentencing has been effective, and I'll give you an example. When the Western Australian State Liberal Government introduced mandatory sentencing provisions for assaults against police and other officers, there was, in just a 12-month period following, almost immediately, let's say, a 28% drop in assaults against police. 28% is an awful lot of difference. Now, that's just one of many examples, but to say that there is zero evidence of the value of this stands very uncomfortably with the Western Australian experience as well as with Labor's past conduct. The other things we can say about this is that the academic opposition that is often proffered for mandatory sentencing is that it's insufficiently flexible to provide reasons for people to cooperate with the justice system. What's interesting about that is that the arguments that have been brought about mandatory sentencing to this chamber today have ignored the fact that the way that these mandatory minimum penalties have been structured in this bill aren't the kind of flat mandatory sentencing that are analysed in the academic context. In fact, this bill provides for considerable flexibility so that there remain incentives for people to, for instance, plead guilty to their offences. There remain incentives for people to not re-offend because those mandatory elements kick in, for instance, at the second offence. So it really is a shallow analysis to say that the academic arguments proffered against mandatory sentencing apply here. So let me explain how it's going to work in this context. Now, if a total sentence is less than 3 years, or 3 years or less, it's a subtle distinction there, a court retains the ability to fully suspend a sentence, but only in very, very limited circumstances, where it is satisfied that there are exceptional circumstances. So that to the extent that those opposites suggest that the removal of flexibility is going to see people refuse to plead guilty because their particular circumstances aren't going to be able to be taken into account, well, there is flexibility in the bill for those sentences of 3 years or less. And for those sentences that are more than 3 years, well, they're the really, really serious ones. And I'm pretty comfortable with the idea that for very serious child sex offences, a mandatory penalty to be served in custody passes the pub test. Now, the real-life stories here should be enough to bring tears to the eyes of those opposite, those who are scoffing now at the fact that this stuff is unacceptable. And I'll give you an example. A man named Gordon Chalmers, Brisbane man, was an academic, a teacher who connected well with his students. He's alleged to have committed 931 offences against children, and his tactics were these, as explained by the police officers involved in that case. He'd pretend he was Justin Bieber online, strike up a conversation with children, girls as young as 13. 157 children fell into his trap. But he wasn't Justin Bieber. He was a polite, bookish, 42-year-old husband and father of two who allegedly sent messages just in the voice of Justin Bieber. He listened. He was a friend to those people online. And then, after isolating the child, turning them to distrust of their parents, he'd ask for a naked selfie or a brief pornographic act. He convinced those children to do things they would never have done otherwise, and then once he had that digital image or video in his hand, he would use it to blackmail them into real-life abhorrence.